Trying to do to me. Think. I don't know the next part. Heart set me free. Freedom, freedom, oh freedom, freedom, oh freedom. Queen of Soul, Aretha Franklin. What is going on, folks? How are you doing? Courtney Rollins. I hope you're doing well. I hope this finds you well. I'm the host of this Life and Transition Experts podcast, and I'm glad that you are here because you may be seeking tools or resources or remedies to help you through a probate process or through selling a property with speed and convenience, or at least seeing what the options are available. Or perhaps you even need help with transitioning a senior into a space. These are all big transitions in life. And that's what this podcast and this resource is focused on, helping you through those transitions, helping folks who help others through those transitions be even stronger and add even more value to make our lives richer and really make those transitions what they're supposed to be, transitions, and not like permanent states of just shock and almost like trauma. Today we're actually looking deeper into the probate space, and we're going to look at the will or wills of Aretha Franklin. As we mentioned before, probate is a very public activity, and there is, as a celebrity, you don't escape it because you're a celebrity. There are tools and instruments you can use to avoid probate, and we'll get into that a little bit as well. But I'll go ahead and share my screen and jump right in. Oh, that's not where I want to go. That's my article. Yeah, check out the Estate Pro Service if you want to see more vlogs and articles of past articles. So let's see. Respect the handwritten will found in her couch, Aretha Franklin's probate. All right. So probate is the legal process of settling the affairs in the estate of a deceased party. If you pass away in the United States, and almost international, but if you pass away in the United States and you have property in your name, real or personal, and you have debt in your name, directly in your name, then there are stipulations depending on the amount, the size. You will more likely, or your estate will have to go through probate. If someone passes away, your estate will have to go probate. Someone has to probate those deals, those issues, so that all your affairs can be settled. And this is a general process in North Carolina. I am the probate expert and specialist in North Carolina, which means I don't know everything. Also, I'm not an attorney or a CPA, not giving legal or financial advice. But what I am is committed to learning the process, sharing my opinions, sharing my experiences, and helping a lot of people along the way. And this is the general process for North Carolina and pretty much across the states. Does happen differently, different words, different phrases, and even sometimes different steps in different states. So definitely encourage you to check out an attorney. If you need an attorney, reach out to me because I can connect you with our vetted nationwide network of state family attorneys. But so if we look at this testate, someone dies testate, they die with a testimony. They leave if you leave a last will and testament, leaves the last will and testament, then that's passing away testate with a testimony. Intestate means no last will and testament, and you did not, that was not left. So the estate has to go through an administration, not an execution of your wishes, but an administration based on the laws of the state. A big myth is that having a will avoids probate. That is not true. If you have other legal instruments in place, yes, you can, but a will has to actually be probated. You have to probate. I don't know if probated is even a term, but a will has to probate. That's how you execute the will. That's how you get the legal right, or that executor gets the legal right to actually execute your plans. So even though you have a will, it has to go through probate. And it sounds like Aretha Franklin had wills. Matter of fact, she had two wills that showed up. When she passed away in 2018, it was stated that it was thought that she did not have a will. So even folks that who you assume may have a lot of just opportunities or connections to folks who can give them some solid financial advice have been seen to pass away without a proper estate plan in place. So there was an assumption that there was no will. So under Michigan laws, all of her assets, everything was going to be equally divided amongst her four sons. However, as time progressed, they found will. In fact, they found two wills, and one was even found in a couch, both handwritten. Only one was notarized, but the handwritten one afterwards was signed, but it was not. It couldn't be self-proving. It wasn't notarized. And so holographic wills, they can be legit. A holographic will is another word for handwritten. I didn't know that. I learned that. That's pretty cool. And it can be valid, especially if it's self-proving. Self-proving means that there's like a notary, a third party. Both did not have witnesses. How could it be notarized if both did not list witnesses? I'm gonna have to look deeper in that, because I thought if you notarize something, the notary has to have. A notary doesn't have to have a witness. They just watch you sign it. Okay, so notary is self-proving. Having a third party witness, perhaps it's not notarized, could be self-proving. I'll have to look into that. That's pretty interesting. So I'll make a note and see. Oh, I need a pencil to make a note. Anyways, I'll note that and figure that and find that out. That would be interesting to know. But I just want to give it real quick 3 ways to avoid probate. Obviously, if you're going through the probate process, that loved one or that one to pass away wasn't able to avoid probate. But here are 3 ways to avoid probate, just to think about. Okay, set up a family estate plan. Go connect. I can connect you with an awesome estate plan that can have you just covered. You have permission to live and permission to pass away at that point, knowing that at least things are covered based on your wishes. You can use different designations such as beneficiary designations and joint rights or survivorship designations on, and title your bank accounts and other deeds in that way, cars and all that stuff. This one is not as strong to me, because what happens if the person you titled to, they passed away too, or it's just a lot of stipulations that doesn't seem to be that may not cover it all. But it is one way to have the real property or property passed through without having to go through probate. And then the asset, my favorite is trust, or either revocable trust or irrevocable trust. These are awesome because you can have a trust own the property, but you are still able to control. And that's the name of the game, fellas. That's the wealthy. Own nothing, control everything that you can, so that so that you can have the proper protection in place. Now, if you need support, we try to provide a hub. I try not to be a jack of all trade, master of none, which is still better than, I can't remember how the rest of the phrase goes. Shakespeare, shout out. But we're just immersed in this space. And so there's team members, there's people that we can connect you with, there's work that we can do on our end. However way we can help, reach out to Estate Pro Service, 919-341-1992, and we will make sure that you are in the right spot, or work together to make sure you're in the right spot. All right. Thank you so much for your time. I got some shout outs. Voice at 100, man, dropping $3 here. Thank you very much. Thank you very much. I hope it's helpful. I hope it's helpful. And if anyone needs support, reach out to me. And what we say always in this Life in Transitions Experts podcast, let your light shine. Peace.